Yes, majama, 19th, Wednesday, it is 3:27 a.m. Saa 9:27. Na mimi upenda kufanya, when there is a burning issue, napenda kuongea na Wakenya saa kama hizi. Ama kurekodi vitu zangu saa kama hizi, wakati hakuna disturbance, kila mtu ametulia. I'll just come to the point, because this is a matter that concerns me. Jina yangu nimeona iko kwa gazeti, which is normal to be kwa magazeti once you are a politician. Naona pale kuna Rigiji, Kawira Mwangaza, Waititu na Sonko. I think this is a response ya Supreme Court wakati walipatia Attorney General 21 days to advise if impeached leaders can vie. Hii ni mchezo mbaya sana. Mbaya sana kwa sababu there are some institutions na nitawadress na with a lot of decorum and respect. Iska tunapigana. But there are some guys who are interpreting the law just to favor their vested interests. Na wale wanajua sheria kama sisi hatutakubali. Maybe kina Watitu watanyamaza, Kawira Mwangaza wanyamaze, Rigiji anyamaze, but mimi nitaongea kwa sababu mimi sijasoma sheria yangu Harvard wala India wala sijui Australia wala Canada. Mimi nilisomea sheria kwa jela ndani. So I understand the law. So hizi institutions ambazo naziheshimu sana. Tukianza na Attorney General. Okay, he has done a response na akasema can impeached leaders vie? AG rejects need for top court advice. Na vile nikiwa Spice FM I talked about this. Nikasema it's the joke of the year. Because we have got previous pronouncements by the High Court. And AG was a party. Yeah. And even IBC was a party. EACC in some cases ilikuwa party. So hatuwezi nyamaza, mimi siwezi nyamaza, because these headlines zinani concern mimi, watu wangu, so I have to talk about this. Na lazima naelezea wa Kenya ukweli. Hii mchezo paka na panya tuache. Kwanza to make the matters worse here, I can read just a sentence, because there is a short documentary which I've done after this intro. Hii documentary itafollow. Mwenye kutaka kuona ataona, it's a long one, around 20 minutes. But there's something I want to read here. The AG has rejected the request by the Supreme Court when she was given 21 days, to give an advisory, an opinion. So there's a small section I want to read by the AG. Mtani allow just nisome very quickly, ndio tuache kupotezea na time. To deal na ukweli na fact. Mimi upata kudila ukweli na fact. AG says impeached leaders election eligibility should be sealed through liquidation, not advisory opinions. These are valid points, Madam Dorcas. It's a valid point. However, there are previous litigations which have already been concluded. Some of them, you are a party. Your predecessor was a party. Now you have taken over that office. So with a lot of due respect, Madam AG, you should have referred yourself to those particular litigations which have already been concluded in our favor. Yeah? Impeached governors. It is there. Yeah? We should not have pending litigations. Those litigations were there. The AG was a party. The IBC was a party. EACC was a party in those litigations which were concluded. One of them is in the documentary that you're about to watch. I remember very vividly. I think I've got those judgments here with me. Napenda kuongea na facts na ukweli. Tutaikujia, lakini moja ni case number E027 of 2022. where a 3-bench judge in Mombasa, empaneled by the Honorable Chief Justice, delivered a ruling, a judgment, and that bench gave the parties right ya kuappeal. Walipewa 14 days ya kuappeal. No one appealed. This was a case on eligibility or suitability, yeah, of impeached governors. Now, because I know this law kwa kichwa yangu, the court walideclare mimi kwenda kwa ballot. My name was on the ballot. I served this judgment kwa IBC na nikapewa certificate. Yeah? So watu wache ku interpret the law ati which litigation, and this is a matter that has already been concluded. Lawyers will check petition number E27 of 2022 delivered on 13th of July. Sitakwenda kwa details, there's a documentary coming there. Mutajionea. Ili declare High Court pursuant to Article 180 sub Article 2 as read together with Article 193 sub Article 3. Also Kanjama alisema juzi LSK chair that president that also Article 99 sub Article 3 katiba imejiregelea na ikasema eligibility ya candidates kuvai. Hiyo iko hapo. So tuache kupotezeana wakati. Yeah, the High Court, yeah, ishafanya it's ruled long time ago. Then there's another case, yeah, by watu wengi sana, human rights, kina Okiya Omtata against us. And hiyo kesi ingine, there are so many petitions filed all over the country to block impeached leaders from vying. And it was concluded. It was a consolidated petition. So many petitions which were filed. And another 3-bench judge here in Nairobi, presided by the late Justice Majanja, Justice Chacha Mwita, Justice Tande Mugure. This one was delivered on 24th June 2022. Yeah, we were being blocked to vie. Petitioners wa Okiya Omtata, kulikuwa na Inuka Kenya, kulikuwa na Wanjiru Gikonyo, Kenya Human Rights Commission, kulikuwa na Transparency International, Edward Osiba and Associates, Mukidi, Anderson Warui, over countless petitioners. They sued, the AG was a party, ESCC was a party, IBC was a party, myself, Paul Karungo Ndangwa, Wiper, Samularama, Jubilee Party, yeah, Commission on Administrative of Justice, all these were parties. Yeah? Also, the cases were E90 of 2022 petition, petition number E168, E221 Nairobi, E230 Nairobi, that is of all 2022. E234 2022 Nairobi. Another one was filed another in Mombasa, E017 of 2022. Mombasa again, E019 of 2022, and Eldoret, E10 of 2022. All these were consolidated petitions. And our bench was empaneled by the CJ, Honorable CJ. And it ruled in our favor. The AG was a party, ESCC was a party, Kenya Human Rights Commission was a party. No one appealed against these petitions. And they were given 14 days right ya kuappeal, walipo 14 days. So, tuache kuharibiana majina ati once you are impeached, that is the end of you. Okay, sawa, let's say Sonko, fate yake ilisha alipo impeachiwa, alipo paliziwa na Supreme Court. Ndipo maliza pili yangu kwa Supreme Court. Sawa. But at the initial stage, nikiwa High Court, I was put on the ballot. I was cleared by the 3-bench judge. 2 benches. Nairobi and Mombasa. No one appealed against those particular decisions. Hakuna mtu aliappeal. So tuache kudanganyana na kizungu mingi mingi. Hata sisi tunajua sheria. Kwa sheria hamwezi kutudanganya. Hamwezi kutuharibia majina. Kama mimi sasa lilikuwa cleared na High Court. Kesi zao bado ziko High Court. Waititu bado wako High Court. Kawira Mwangaza bado wako High Court. Rigiji bado wako High Court. Kwani do we have law for Sonko and law for other leaders? And I want to repeat myself. Article 193 sub Article 3. Also Article 99 sub Article 3. Zinaongea about impeached leaders. If you have an active appeal challenging that decision which removed you from office, the law says utakuwa kwa ballot. And the law does not end kwa appeal. The law says, review. Wala wajui review. Umeshamaliziwa kwa appeal. Umemaliziwa kwa appeal. Umepata new evidence. Kuchallenge that appeal. That is a review. The moment you file that review, you're supposed to be in the ballot. Na kama umekuwa impeached, the moment you challenge that particular impeachment in court of law, the Constitution does not say that you must overturn. No. Hiyo mnaongea tu mambo zenu za kumsidi watu wale hawajielewi na hawajui sheria. Watu wamelala hapa. Si hatujalala hapa. The law says if you have a pending appeal, when that appeal is pending, immediately it is filed, you have a number at the registry, you're supposed to be on the ballot. Even if you have lost your appeal, you have filed a review, you're supposed to be on the ballot. Just follow that documentary, part 1. Maybe after some few days, I'll come with part 2, part 3, tutaendelea. Pole tu. So, poleni sana kwa hiyo press conference, but I feel it is right, it is my constitutional right also to express myself. We have got freedom of expression in this country, bado iko enshrined kwa constitution of Kenya. Kwa hivyo, hiyo ndio ukweli. Mwache kutudanganya ati pending litigation. You are parties in those particular litigations. Kwa nini mnakuja kumislead wa Kenya, and we are being paid a lot of money, our money, taxpayers' money. So, stop misleading Kenyans. The same respect that we are according you guys, hata mtupatie. Sisi, we have got, hata kama we are impeached, there is the Kenyan Constitution, which was promulgated in the year 2010. Watu wache story mingi hapa. Musifavor law kufavor interest zenu. And the law is very clear. Chani kudanganya watu. Thank you so much, guys. Enjoy the rest of your Wednesday. Tutachapiana tena. Tarudi tu hapa tuchapiane tena. Based on the law and the facts and the history that is there and the previous pronunciations by our judiciary. Law should not be applied selectively. Sawa. Thank you so much. Ebu oneni hiyo documentary ya 22 minutes. Sana nyinyi lawyers. Mwangalia hapo. Msijali Kizungu. That is a foreign language, but fuatilieni hiyo documentary. Asanteni sana majamaa. I love you so much.
Impeachment case. I've been seeing senior lawyers, so many people interpreting the impeachment law to favor their interests, including our own Chief Justice, whom I have a lot of respect for. We respect our Chief Justice, the President of the Judiciary here in Kenya. There are some careless remarks you made when my case was still active before the Supreme Court. Our Chief Justice went to Spice FM around 20th of May or 22nd of May. I'll check my records. And she was talking about my impeachment. She said, I remember very vividly the remarks that once you're impeached, you're impeached.
When you're impeached, you're impeached.
Once you're impeached, until that impeachment is overturned, you cannot be allowed to vie. And we're not going to allow governors who have been impeached to vie. Myself being a victim by that time. My case was active before her court. And she was making these remarks, very misleading remarks, contrary to the Constitution of Kenya. The law does not say that. And the Chief Justice of the Republic of Kenya, remember when I was impeached here in Nairobi, I went to try my luck in Mombasa. I was vying in Mombasa. So many cases were filed against to challenge my eligibility of vying. There's some subject justice empaneled a 3-bench judge in Mombasa, led by a judge, I remember very vividly, a judge called Gachagua presiding, Justice Gidinji and Justice Ongito, 3 judges. My case was heard, and the court ruled in my favor.
Thanks again for joining us tonight. Now, former Nairobi Governor Mike Mbuvi Sonko can now heave a sigh of relief after a Mombasa court earlier today ordered the electoral body IEBC to accept his nomination and allow him vie for the position of Mombasa governor.
Article 79 of the Constitution was in contravention of Article 47 and Article 180 sub-article 2 as read with Article 193(3) of the Constitution.
The judgment, the judges said, the main declaration which was declared, and I don't know why today the lawyers, especially in the Gachagua case, they don't want to implement this judgment, which has never been appealed by any party to date. It still stands. The judges said a declaration that the petitioner is eligible under Article 180 sub-article 2, as read with Article 193 sub-article 3 of the Constitution, to vie as a candidate for the seat of Governor Mombasa County in the 4th general election, stated for 9th August 2022. I was cleared. Went to the returning officer, IBC Mombasa, Madam Swalha. I served this order. I was given a certificate of IBC with my deputy governor. Tukaekelea mkono hivi juu, yeah.
Meanwhile, former Nairobi Governor Mike Sonko is now back on the ballot. The Independent Electoral and Boundaries Commission, IEBC, has cleared Sonko to vie in the Mombasa gubernatorial race.
But what happened, after some few hours, the Supreme Court brought served us with a hearing notice to say that they need us on the 14th, the following day after this judgment, to hear our case. Get my point? But I don't know why, guys, they cannot talk about this judgment. Even in the Gachagua's case, everybody was telling the judges, that 3-bench led by Justice Ogola, Justice Mbrima, and another lady justice, that in the Sonko's case, Sonko's was banned by the Mombasa court. Sonko was not allowed to vie, which is a lie. Sonko was allowed to vie, and the evidence is here. The 3-bench judge cleared me. And I remember even at that, the clip is there, I will air it at some point.
Meanwhile, former Nairobi Governor Mike Sonko is now back on the ballot. The Independent Electoral and Boundaries Commission, IEBC, has cleared Sonko to vie in the Mombasa gubernatorial race.
Now, former Nairobi Governor Mike Mbuvi Sonko has been cleared to vie for the Mombasa gubernatorial seat.
The judges, the 3-bench judges, they told the respondents that you have a right of appeal within 14 days. Nobody appealed. I think now the problem, this what is mingi, something is wrong with them. They cannot differentiate between a case of eligibility and removal from office. It's 2 different cases. What Supreme Court did, they went and upheld my impeachment because I had filed my appeal at the Supreme Court, which was active, because I was still fighting for my reinstatement as governor of Nairobi. So by that virtue, my impeachment case was still active. Even by the time Martha Koome, whom we have a lot of respect for, went to the Spice FM to talk about my judgment.
When you're impeached, you're impeached. That is exactly what it is. If you are impeached, you are impeached.
I want to repeat myself. That's my appeal was very, very active before I got. And I want to tell Kenyans and lawyers who are listening, This was a miscarriage of justice. It was a very, very bad precedent that was set by the Supreme Court, led by Martha Koome herself. Because being the head of the judiciary, she knew very well she had impaneled a bench to hear my case on the 13th of July. Then here she comes with a hearing notice, ambushing us, telling us that we are supposed to appear before the Supreme Court on 14th for the hearing of my appeal case, which is lying at the Supreme Court. Little did she know that she had flouted her own rules. I have the Supreme Court rules here with me, which say if you have filed an appeal before the Supreme Court, after filing, you wait for the directions of the Supreme Court from the Deputy Registrar of the Supreme Court. She'll give a guidance. Now that your appeal is filed, you are given 14 days to bring all your evidence, all your submissions, file, then serve the respondents. That is what we call the directions of the court, the rules of the court. Now, once the respondents, now in this case, the respondents are maybe IBC, Senate, County Assembly, Attorney General. These are the now respondents because I'm the appellant in this particular, I was the appellant in this particular case. Now, after the respondents receive those submissions and affidavits and evidence to support my petition, they'll be given time, 14 days also, or let's say between 7 to 14 days, to do what is called a response to your submissions and file and serve. Then as the main appellant or petitioner, I'm also given time to read the responses by the respondents, yeah, and prepare what is called a rejoinder, file, serve the respondents. Those are the Supreme Court rules. It doesn't end there. Once that is done, a date is fixed by the Deputy Registrar of the Supreme Court to check whether parties have complied with the directions of the Supreme Court. That is called a pre-trial conference. It is either done virtually or physically, whereby all the parties will come for hearing, either virtually or physically. The Deputy Registrar of the Supreme Court, in this case now, asks the parties, have you complied with the directions we gave? Or maybe there's a party that has not complied. It will raise and say, no, Your Honor, because the Deputy Registrar is incumbent to a magistrate. Your Honor, not yet. I was held up somewhere. I pray for more time. Any objection from parties? No. You are granted time. Another mention date is given. You come, all of you, to court. You engage until you agree. Once you agree that compliance has been done, the Deputy Registrar will take the diary of the court. We have a date of 23rd of August. Is it convenient to all the parties? Maybe Sonko's lawyer will be busy in the Eldoret court. He will tell the court, no, Your Honor, that day I'll not be available. Can we check another date? Then the Deputy Registrar will give another date. Okay, 23rd August is not convenient. Can we check 9th of September? So they'll engage until all the parties are satisfied with that particular date. Then that date which will be taken, it will be fixed by the court, and all the parties will comply with that particular date. Then that is the date where the file now will be brought before the Supreme Court, before the bench now, the 7 judges or the 5 judges, for the matter now to be heard. But in my case, it was very different, and I was shocked because the Chief Justice hurriedly, number one, ambushed us illegally, flouted the Supreme Court rules. The court was being run as if it is a kangaroo court. Because after she realized that we were going to get a favorable judgment on the 13th, directions were filed and served on the 12th. We were told to file, the petitioners were told to file their responses by the 13th in the morning. As no, them they were told to serve by
Close of business.
as we are supposed to serve and file by the 13th.
Before midday.
The same day, our judgment hearing was ongoing, where I was in court with all my lawyers from morning to evening. And then in the same directions, we were being told that after filing, physical copies are needed at the Supreme Court, Nairobi. What she knew very well, she had empaneled this bench, and this bench was hearing my case. And this bench had given the 13th of July as the date of judgment. Well, the same Supreme Court had given the 13th of July, the day of serving our physical copies, for a first hearing date of 14th. I want to remember that day. A case that had over 14 parties, almost 1 million words, was heard within some few hours.
Supreme Court has brought to an end Mike Mbuvi Sonko's short but eventful and flamboyant career in elective politics. Chief Justice Martha Koome dismissed Sonko's claims that he was not accorded a fair hearing. Sonko is now effectively locked out of the Mombasa County governor's race barely 24 hours after the electoral body IEBC cleared him to contest.
And to make the matters worse, after realizing all these mistakes have been done against us, my lawyer did a protest letter to the Supreme Court. They received the letter on the 11th, and they responded. I think about that response. It's a very, very sad situation. Very, very sad situation. Later here. This is a hearing notice for 14th of July. And these are directions to tell us that we should file the hard copies on the 13th July 2022, where we were busy in court before a bench which was empaneled by the same Chief Justice who is giving another hearing notice of another case. While she knew very well we were busy in a court that she had empaneled herself. Now, my lawyer did a protest letter, and I'd like to just read just one sentence of this letter. A serious, okay, the directions issued by the court on the 11th of July 2022 presuppose a situation where the petition had received responses and even filed submissions, which is not the case. We are telling the Supreme Court, a serious miscarriage of justice is likely to occur on the part of the petitioner should some of these important processes are bypassed. We urge the court to issue directions that will allow the petitioner to await responses from the respondent and allow him to file the supplementary affidavit, if need be, with enough time to consult with counsel for purposes of rejoinder. On behalf of our client, as we also appreciate the urgency of the matter, we plead with the court to consider his concerns and let the usual procedure to prevail, as this matter is not only about the petitioner, but also protection of the sovereignty of the people of the Republic of Kenya. Now, on receiving this protest letter, the Supreme Court checked their records and found that they had committed a serious blunder, a serious miscarriage of justice. They wrote a letter, they replied, they responded on the 12th of July, addressed to my lawyer, Supreme Court of Kenya. The heading is my case, the impeachment case. Now, This is what the court said, the deputy registrar. The letter is on the letterhead of the Supreme Court. Supreme Court of the Republic of Kenya refer to the above subject matter in which directions were issued on the 11th July 2022. It has since come to our attention that due to inadvertent mistake, directions were not issued in respect to the petitioner filing submissions in support of the petition. We apologize for this oversight and hereby enclose further directions for compliance by the parties. Yours faithfully, Honorable Letizia Oshira, Registrar of the Supreme Court. By then, she was our Chief Magistrate. Today, she's our judge, who's also my witness, because she's the author of this letter, in her capacity by then as the Deputy Registrar of the Supreme Court. And after consulting the bench, because before you give directions of this nature, you have to consult the Chief Justice as the President of the court. So after consulting the Chief Justice, they were all in agreement that they had committed a serious miscarriage of justice and they should apologize to us. That's how this letter was written, for apology. Now they apologized. Even after apologizing, they issued the same directions. Further directions were issued. And repeated the same, nothing changed. Yeah? Filed by us as the petitioners. The petitioner filed and served a soft copy of his submissions by midnight, same day. The respondents to file and serve a soft copy of supplementary submissions by 10 a.m. on 13th July 2022. The same day, the judgment was being read. And as the petitioner, we are being told within the next 2 hours to file a soft copy of our rejoinder. That is by noon of the 13th day of July 2022. Now, to make the matters worse, and the joke of that year, we were told to file all the hard copies of the filed responses and submissions within the next 2 hours, physically at the Supreme Court registry. While they knew very well our judgment was being delivered on the same date. This is a clear indication that our right to fair hearing was infringed. And remember, these two directions, the first direction and then the further directions. First direction, as I said, were done by Letizia Washira, who's a deputy registrar. Then the further directions were done by a different registrar called Honorable Bernard Kasavuli. And these final submissions, the filed ones, were very voluminous. And remember, we were in Mombasa for our judgment. Then at the same time, we were being told to serve all the filed hard copies at the registry in Nairobi. Isn't that justice? Because we respect the judiciary, I told my lawyers, let us attend court. Yeah? Let us attend court. We attended court to attend the hearing of 14th. Remember, the High Court had declared me on the 13th. However, on the directions of the Supreme Court, after the protest letter, on the new directions, the court said that the matter will be listed for hearing of the petition before a 5-bench judge on the 14th July 2022 at 9 a.m. My clearance was done this day.
The final decision on whether or not former Nairobi Governor Mike Mbuvi Sonko will be on the ballot in the Mombasa gubernatorial race is pending a ruling to be delivered on notice by the Supreme Court, as the IEBC Thursday cleared him to contest the Mombasa top job on the High Court's orders.
Sonko's impeachment case went on at the Supreme Court, where he filed an appeal challenging the decision by the Court of Appeal and the High Court. After hearing all parties in a virtual sitting Thursday, Chief Justice Martha Koome stated that the Supreme Court will deliver its judgment on notice, meaning that as and when they are ready, the decision is expected to inform IEBC on whether the former Nairobi governor's name will make it again to the ballot.
Because we finished the High Court when I was cleared on the 13th in the evening at 6:30 p.m. is the time I was leaving court. So we were forced to attend this case on the 14th. However, my clearance happened the same day. When I took our clearance, then we had to go for this case. Now we were shocked because as per the direction of the court, they misled us that we are going to face, or our matter is going to be heard before a 5-judge bench of the Supreme Court. But we are shocked to find a full bench. This is like deceit, misleading directions. Okay, we are shocked to see the Chief Justice, whom we respect a lot, head that bench as the presiding judge of that bench. What do? We complained bitterly and told the Chief Justice, can you recuse yourself from this matter? Because you had formed an opinion the day you went and commented on this matter at Spice FM. They consulted each other, the judges declined. They did a ruling and declined to recuse the Chief Justice. She said, where is the evidence that I was at Spice FM talking about this case? Well, she knew very well we were busy in a High Court, which she had a panel for hearing of our judgment. We do not have time to go and download the clips and bring. She never gave us time. It was just an ambush. So that was what transpired. They refused to recuse the CJ. The matter proceeded by force. It was a serious miscarriage of justice. The case proceeded on the 14th for like several hours. 15th, before midday, my political life ended. They upheld the impeachment and the decision of the Court of Appeal. So I don't know what time did they get to go through the proceedings, to read the proceedings all the way from the Court of Appeal. Yeah. A judgment was written within a few hours, and my political life ended. I never gave up. I never lost hope. Because remember, I had the certificate already. Based on the judgment of the 3-bench judge, I had the certificate. But based on the removal of office case, my impeachment was upheld. But the bench for eligibility, nobody appealed. It stands. Anybody, including Gachagua, Kawira Mwangaza, are supposed to be on the ballot. Why? Because they have not exhausted their avenues of appeal. And even if they exhaust, even if your appeal is concluded and the impeachment is upheld, or the removal of office decision is upheld, and you still have, after some time, a new evidence emerge. Yeah, you have new evidence that has emerged. Based on that new evidence which you have, you can approach the court again and tell them this judgment has some loopholes, and here are the loopholes. Now that is called a review. Okay. You are seeking for a review of that particular judgment. Well, immediately you file it. Immediately it's filed. You have a number at the registry. You're supposed to be on the ballot.